and I think it's absolutely critical that our listeners are aware of this. And this is a little bit of inside baseball, but this can have an enormous effect on Governor Pritzker's unconstitutional assault weapons ban. And Scott, I'm going to sort of provide just very brief background, but I want to ask you about this because I think everybody needs to know what's happening. But as you know, Tom DeVore, former Attorney General candidate, filed multiple lawsuits in Effingham County and White County and in other jurisdictions, and received a temporary restraining order, all on one issue in particular, which is the Equal Protection Clause, which basically is like discrimination, that it creates different classes of people. You can get it's like Oprah, and you can get assault weapons, and you, and you, and you.
But not you.
But not you, right? And the not you is very interesting. The not you could be veterans, retired military. And so it creates it's discrimination. And it's fascinating. But, and I'm careful because I'm not one to want to level attacks, but this Dan Caulkins, Republican State Representative Dan Caulkins in downstate Illinois, has filed a similar lawsuit, nearly identical to DeVore's. They didn't do the research. They just literally probably lifted everything from DeVore's lawsuit and put his name to it and said, this is mine. And he's now trying to own DeVore's Equal Protection Clause argument. Nobody else has that argument, and DeVore's been incredibly successful. But Scott, I don't know if it's insanity, if it's a drive for fame, if it's to see his name in the headlines. But for our listeners and those watching online, something dangerous is potentially about to happen that's going to jeopardize all these cases and all the work, hundreds and hundreds and hundreds of hours of work that Tom has done, thousands and thousands and thousands of pages. And how many plaintiffs in total, Scott?
Mark, there are 4,700 Illinoisans and 168 FFLs, gun shops, who are plaintiffs right now. I understand that tomorrow or Tuesday, there's going to be a couple thousand more joining those cases. So it's going to be a total of 7,000 plaintiffs.
So explain for Scott, how has Republican State Representative Dan Caulkins, how is he potentially, and I think it's almost a near guarantee, how has he jeopardized this assault weapons ban challenge via TRO for every gun owner in Illinois? What's going on? Explain this.
Sure. You mentioned the temporary restraining orders, which Tom DeVore won with the same argument. Caulkins also received a temporary restraining order for himself only. And those temporary restraining orders...
for himself only.
Well,
it's true.
We can get into that too. He tried to name an association, and although it's listed on the complaint, no gun shop is honoring the TRO with respect to this alleged association.
Because it's not real.
It wasn't set up right. But so Caulkins has a TRO, and the 4,700 plus plaintiffs in Tom DeVore's cases have a TRO. And that temporary restraining order says this. It's the judge saying, I believe, Tom DeVore, that you're likely to win on the merits on this equal protection argument. That's not saying go take this to the Illinois Supreme Court and see what they think. What that's saying is go develop your case. Go out there and prove that there's no explanation for all these weird exemptions. You know, DeVore thinks those exemptions are there for a reason in order to get the bill to have passed. It was to appease different lobbying groups. The fact that an exempted group is private security, essentially mall cops, is really weird. And that clues you in that maybe there was a powerful interest that wanted that in there in order to get the votes for this gun ban to pass. And so what Tom is going to do through his cases, he's served discovery requests on the governor, requests for admission, that there is no basis for these exemptions in the law. And, Mark, the way these things work, you serve the discovery requests, they're supposed to answer them. Pritzker's refusing to answer. In fact, it's very interesting. He's claiming executive privilege that he doesn't need to tell you. He doesn't need to tell you why there's these exemptions in the law. And, that's the sort of stuff that you want to gather up, you want to prove in order to prove your case, and ultimately take it to trial. Probably the last thing you'd want to do is run the Supreme Court, and it turns out that's exactly what Dan Caulkins is doing.
So he's essentially circumventing the process of due diligence, of gathering, of discovery, of subpoenaing Governor Pritzker's records, of subpoenaing Chris Welch, the Speaker of the House's records, right? And they're scared to death of having to turn this information over because it's going to be very damaging to their case. So Caulkins is skipping that entire process and going directly to the U.S. or the state Supreme Court. Why would he want to go directly to the state Supreme Court and skip this entire process of gathering evidence?
Well, you'd have to ask him. I've been very cautious to make any accusations myself, Mark. But at this point, it can only be that there's some sort of deal between Caulkins and Pritzker. It's the only thing that makes sense at this point. You wouldn't want to risk, if you're Caulkins, you wouldn't want to risk upsetting all of these TROs, which, in a couple of days will benefit, 7,000 Illinoisans and over 200 FFLs, gun shops. That's 200 business owners, small business owners, and all their employees who could be out of a job if this TRO is upended.
So is the state Supreme Court, are they going to hear this at Caulkins' case?
They are. It's a direct appeal, which means so
the files could be pretty thin.
Well, very thin. There's no record. It's going to be like 4 documents. But but Pritzker and Caulkins made a deal. We know they made a deal because they started briefing summary judgment motions together, which then and that's what
is that
Caulkins
indicative
prevailed on.
In a legal perspective? That's indicative of some sort of collusion.
Well, they had to at least agree that, hey, we're going to do this.
Okay.
We're going to, because simultaneously they briefed, and on different issues, by the way. Caulkins briefed his on the Equal Protection Clause issue, and Pritzker brought some other unrelated procedural issues. They had nothing to do with one another. And then that judge, that Macon County judge, granted Caulkins, on Friday, granted Caulkins summary judgment and entered a final judgment in the case. That order right there is a page and a half long. It's conclusory. It just says, yeah, the Equal Protection Clause is violated.
So Scott, let me get this straight. So, and this is so important for our listeners, DeVore was providing a substantive case with volumes and volumes and volumes of information gathered during discovery, information that was going to make Governor Pritzker very uncomfortable and the Speaker and the House and Senate leaders very uncomfortable, and was going to prove or show potentially corruption in the creation of this and passage of this legislation.
It could.
Because of it's possible. It's possible.
It would at the very least expose who the power players are.
Expose. That's it.
And that's, I think, what J.B. Pritzker wants to keep a lid on the most, because none of us really know how this bill came to be. It was gutted and replaced in the last 48 hours before it surfaced for a vote.
So Caulkins has fast-tracked his lawsuit to the state Supreme Court, which is 5-2 in Democratic.
Yeah, that's the other reason I don't want to go there. I mean, it's begging reversal just right there. This bill, this gun ban means everything to a future presidential candidate, J.B. Pritzker. And let's be honest, he's a future presidential candidate, J.B. Pritzker. And to go out there, he was in Davos when this thing passed. He was in Davos bragging to all those globalists, that he got the gun grab bill pushed through, and that, they were applauding him. He was like a hero, and he needs this thing to hang around a little bit longer. I think ultimately it will be struck down on Second Amendment grounds, but he needs it right now.
So the state Supreme Court is going to listen to this with virtually no evidence whatsoever, paper thin, on the Equal Protection Clause, 5-2. If this is reversed, every gun owner in Illinois is screwed. We're going to talk about this a little bit more. George, I really only have a minute left. Keep going.
Make sure that you